What is a will and why do you need one? Listen in as the very knowledgeable attorney Joseph A. Marra discusses wills, the pitfalls that you might deal with, and really what do you need in there? What do you have to consider and what are the right strategies? So listen in as Joseph A. Marra explains what you need for a will in New York.
We're going to talk about wills and trusts, okay? And let's talk about first, this is very, very important. And I want you to focus on the language in bold. The will only controls assets that are in the person's name alone. What does that mean? Well, just what it says. It has to be in your name alone. You say, well, I have an IRA and I name my wife as my beneficiary. Is that in my name alone? No, it's not, because you have a designated beneficiary. Well, I have a bank account that's POD, pay on death. Is that in my name alone? No, because you have a designated beneficiary. I have a bank account that's joint. Is that in my name alone? Absolutely not. I have my deed joint. Is that in my name? No. Okay. It's assets in your name alone, meaning you're the only name that appears on the document. Here's an exception to that. A deed can have two names on it. All right. If the person on the deed with you is not your spouse, it is assumed that you own that property as tenants in common. What does that mean? You each own half. So if you own a property with your brother and it doesn't say things like joint tenants with right of survivorship, well, you own half the property, your brother owns half the property. When you die, your half goes to your estate. When he dies, his half goes to his estate. If the deed said joint tenants with right of survivorship, then the last one of the two of you gets the entire house. A lot of people don't understand that, particularly when it comes to real estate. Extremely important. So once again, going back to the will, okay? The will only controls assets in your name alone with no joint account designation, no beneficiary designation, no in-trust for designation, nothing but your name, okay? So I said the only exception is tenants in common asset, which is usually real estate. There could be other things that are tenants in common, meaning I own my half, you own your half, but the most common one is real estate, okay? So people say, well, I wrote a will and what if I sell my house? No, so what? But I put my address in there, it doesn't matter. Or I have 15 shares of IBM stock and I wrote them in the will. Well, I wouldn't recommend doing that, but the will doesn't take effect until you die. And if you leave, let's say you left an asset and you no longer own it. I leave my 15 shares of IBM, it's sold. Well, that's called a lapse. It drops out. It's like it's not there because the asset's not there. So what I usually do is I recommend that people do in their wills percentages and specific amounts. All right. Now, when you do specific amounts, they take precedence. And this is the other reason why you have to be consistent. Your estate plan has to be consistent because remember, joint accounts, they go as the account says. For example, if you wrote a will and says, I leave everything to my cousin Louis, but your primary asset is a bank account and I'm joint on the bank account, guess who's getting the money? Me or your cousin Louis? Me. Now, there are exceptions to that can be challenged, but that's the general rule. So if you had $1 million bank account with me and it says I leave everything to Louis and there's only 100,000 in your name, Louis gets the 100,000, I get the $1 million. Now, could he try to challenge that? There are various grounds to do that. We're not going to get into it here. Just know there are exceptions. But as long as your estate planning is consistent, you don't need to worry about the exceptions and fancy lawyering. Just set up things right and things will go the way you want. Okay? So remember, it's used to transfer assets on death in one's name alone. It's not effective until you die. And the will has to be admitted to probate. Well, people ask, what is probate? Right? Well, simply stated, a properly drafted will is submitted to the court with other documents. If everything goes according to the way it's supposed to, the court will then issue what's called letters testamentary. Okay, that gives the named executor the power to act according to the terms of the will. So once again, will has to be drafted properly. It's submitted to the court, and then the court gives you the power to act as executor according to the terms of the will. Well, what does properly drafted mean? Varies from state to state, of course, although pretty similar in most states. Witnessed at the time it's signed by 2 witnesses and attested, something called an attestation clause. All right. Also, there's an affidavit that has to be submitted with the will. And basically, it's an affidavit that says a number of things: that you were there, you witnessed the will, the testator acknowledged it was their will, they signed it in front of you, they signed it in front of the other witness, they were over 18, they were competent. That's what this affidavit says. When can the affidavit be signed? Only 2 times: within 30 days of the will being signed, or when the will is offered for probate. Now, I've gotten many wills in my office that were not drafted by me, where the attorney failed to attach the affidavit to the will at the time it was drafted. So you can imagine getting a will from 1992. Okay, who are these witnesses? I don't know. Can't even read their names. All right, so now we got to go, is the lawyer who drafted the will still alive? That's when the probate process becomes, expensive, time-consuming, and stressful. So that's why all my wills, I have my affidavit done. At the time the will is signed, I staple it to the will. Therefore, when the will is admitted to probate, you don't have to go chase witnesses. The only time there's an exception to that, 2 times. 1, the testator dies within 90 days of executing the will, and then the court may want to hear from them. Well, if it's only 90 days, it's not going to be hard to find, right? The other time, if there's a will contest, then they may be called upon to testify. That's it. Will contest, meaning someone is contesting the will, right? So another thing that people ask about is, what if I don't have a will? What happens then? What happens to my money? People say, well, it goes to the state. Can it go to the state of New York or wherever you live? Yes, it can. Will it? Probably not. Why? Because the state generally writes a will for you. It's called the intestacy statute. In New York, our intestacy statute is pretty specific. One thing people don't realize, or find surprising, say one spouse has all the money in their name alone. Now remember, if it's joint, you don't need to probate the will, right? That's what we're talking about. But husband or wife put everything in their name alone, and they die. And they had no will. So what happens? Well, now there's no probate, but you still have to go to the surrogate's court, and you have to file what's called an administration proceeding. Okay? And in the administration proceeding, the people who would get the money under the statute have to be notified. Also, one of them has to petition the court to be the administrator, to do the job that the executor would do if there was a named executor. So you have to have an administrator, someone to petition the court and say, hey, this person died, they have $500,000 in their name alone, and I want a petition to be their administrator. So what does this statute do? Well, people find this unusual, husband and wife situation. The statute provides that the first $50,000 goes to the wife, and if there are children, the children get half, and the wife gets half. That's what New York's will. People find that surprising. Well, what if I have no wife? I just have children. Well, they get the money. What if I have no wife and children and my parents are alive? The parent is alive. Parents get the money, and so on. Brothers and sisters, nieces and nephews. The statute goes out as far as first cousins once removed. Okay? So if you have a first cousin once removed, that somebody known as a laughing heir, and you had no will, they might end up getting all your money. That's first cousins once removed is basically the cousin of the child of a first cousin. That's how far they go out. So now the other side of this is, I have people come to me all the time. I am 75 years old. I'm single. I have no children. I have no siblings. All I have is cousins. Say, okay, well, if you do a will, what's going to happen is when you die, these cousins have to be notified. Well, why do they have to be notified? I told you I want to leave it to charity. You can leave it to whomever you want. But the law requires that your cousins be notified. That's what the law, I don't even know where they are. Well, there's a way of getting around that. We'll talk about that in a bit. Let's go back and we'll finish up on wills, okay? So we talked about the probate process. We talked about the will has to be properly drafted and properly witnessed with an attestation clause. Extremely important. And like I said, people have a tough time with this concept. It only controls assets in your name alone, all right? So only with your name on it, that's it, okay? The executor is the person named in the will. They're responsible for gathering the assets, distributing under the will, and they are entitled to commissions, okay? As I said before, these assets, PDF, POD, or, joint tenants or right of survivorship, they don't go through probate and they go where they're designated in those documents. Are there ways of challenging that? Yes, but they're limited. Specific assets, they can be mentioned in the will and given to specific people. Sometimes that makes sense. So you talk about a valuable piece of artwork or something like that. Yeah, it makes sense to do that. Generally, it doesn't. Usually, like I said, it's best to put things in percentage forms. And another thing too, some people leave their assets to charity. One thing you should know about if you're doing this through a will, if you leave a percentage to charity, the Attorney General of the state of New York becomes a necessary party and they have to be cited. So you now have to involve the Attorney General's Charities Bureau if you're leaving a specific percentage of your assets pursuant to will to a charity. So I say either leave them a specific amount of money, okay? But remember, when you leave someone a specific amount of money, they get that money first. So that's also something to consider. How do we avoid these things? We'll get to that in a minute when we talk about trusts. How long does probate take? Well, generally, I tell people approximately a year. They go, a year? Why so long? Well, here's the reason why. We have to go through the probate process. And in New York, because of COVID and because of changes in the law that were made before COVID, it now has become very difficult, right? In the past, say you had a spouse and children, nobody was disabled, everybody got along, the kids were adults, so on and so on. You didn't have to worry about estate taxes, which we'll talk about later. You had a fairly simple estate, no property in another state. I would say, you don't need to do anything, just do a will. I don't tell that to people anymore because probate takes a while now. And I will just give you a quick example, okay? I had a estate a number of years ago, before COVID, okay, where it was two children and the mother had predeceased, so everything was going to the two children. One of them is the executor, the kids got along, no problems. Daughter lived, I'm in Westchester County, daughter lived in Suffolk, and she's like, Joe, just send me the papers so I could sign them. I'm like, okay. Sent them to her, and they had to be notarized and acknowledged. An acknowledgement is different than a regular straight notary. So in that acknowledgement, you have to put the state where it was signed and the county. I left it blank because I didn't know if she was going to have it signed in Nassau or Suffolk County. Came back to my office. My associate at the time didn't realize that the notary forgot to put the county in, okay? And she filed it 4 months later, get an email from the probate clerk. We're rejecting your petition because it wasn't initially, the county wasn't put in. So now I look like a fool, right? I had to call the client up, resend the stuff out, send it back, another 4 months. Whereas, say, 10 years ago, I would have gone, walked the papers into the clerk's office, sat down with the clerk. Clerk would have looked them over and said, hey, Joe, there's no county here. Write the county in. And I would have had letters testamentary in 2 weeks. Now, this was before COVID. So now you can imagine the state, basically in New York State particularly, they was very short staffed. They didn't bring everybody back in until around Memorial Day this year. So you had a time when nobody was there. Then you had a year when there was very short staffing. You had a lot more people dying. So the surrogates court is backed up. So when I used to say to people, oh, don't get a trust, now I tell them, I think you should get a trust.
Thank you so much for listening to our video. If you have any questions about the information that you've heard today, please don't hesitate to contact the law offices of Joseph A. Marra. They are experts in what they do and more than willing to help you get the right strategies in place so that your estate planning makes sense and that it works the way you need it to. Thank you so much, and we'll look forward to hearing from you.